Yeah, well, most of the time, if people really sat down and read it, they wouldn't sign the contract.
Yeah, well, I'll tell you what, that's happened on the internet when you have this bit about I agree.
Uh-huh.
You don't read everything.
No.
And you don't know what you're agreeing to.
Right.
And we all do that, and that is a real perilous practice.
Yeah, it is. They should read, even if they take one, just read one of the things, like if you go onto a line and they say, join this club, or in order to go to the radio station or the TV station, you have to agree to the terms. Well, just, you don't have to read them all. Just take one and read entirely through the terms. And most of them will be shocked at what they got themselves into when they agree.
Yes. All right. Therefore, where are we now?
Oh, okay. Well, let me start with this letter. This letter was to the friend, and I said, we were talking about the John Barron case, and this fellow was supposedly a guru, and he was claiming that he never lost the case, and he was doing this, and I had sent a letter to him in email, and I told him he was wrong, and so on and so forth, and of course, they say, no, he was right and I was wrong, and so on and so forth. Well, after a while, it got to him, and he started reading something up on it, and he wrote to this guy, and he says, you know what? I just found something, and this is 2000 now. He says, I just found something that I couldn't believe it, and it wasn't my stuff, but it was based on my stuff that I told him previously, about 6 months to look at it. And he says, man, I got to rethink all my stuff. So this guy wrote me the letter and sent me what he sent him. And I says, yep, so this is why I wrote the letter back to this fella and say, well, you could use a lot of this stuff to show him. Because I didn't want to be bothered with arguing with him because it never gets anywhere.
Right.
So, this one here, I did have a constitutional law book titled Cases of Constitutional Law. All right, and it's ripe in cases on John Barron, and it's more than 1,086 pages. There are cases in there that weren't brought up; they're just important. And I says to him, one being Hepburn and Dundees versus Elazee, and it's 2 Cranch 445. In case any of the listeners want to pull it, which I suggest they do.
Would you repeat that, please?
It's Hepburn and Dundas, Dundas. Versus Elazee, Ellezey. And they can find it, not online, I doubt it. It's in the library, and it's 2 Cranch 445. Cranch is the clerk of the court back those days, and any time you see Cranch or a name after it, that means that the case is before they gave it U.S. code numbers, and it was the clerk of the court, and that's why this particular one is Cranch.
All right, so when you see that it predates...
it's like in the 1790s and the early 1800s.
What is your guess as to when this case was adjudicated?
I do have the case here, but I can't reach it.
That's okay.
And I think it was right around 1800, 1802.
Okay.
And in there it says, now this is where, people have to read it. It's hard to understand it on the radio, but the words are there, and when they read it, it's different, you know what I mean?
Mm-hmm.
A citizen of the District of Columbia cannot maintain an action against a citizen of Virginia in the Circuit Court for the District of Virginia. A citizen of the District of Columbia is not a citizen of a state within the meaning of the Constitution. That's the quote. And I said to the fellow, reading this, it goes way over people's heads, and they're not aware. As Montgomery found out, the President Washington created the states as districts in 1791. Hence the phrase, District of Virginia in the above case. See, people looking at it, District of Virginia, it just goes over the head. What is the District of Virginia? Well, it's not Virginia, that's for sure. like I said, it's important to get the case and read it. It's ripe with info that will wipe out the myth that the people had on jurisdiction.
One quick question, but when you hear about people going to district court, is that a result of that kind of terminology?
Yeah, because you see, when Washington created the districts in 1791, it was because of the banks. And they had to have districts because they had control of the banks, and they would not allow the states to control the banks. And that's why the McCulloch, Maryland versus McCulloch was brought up when Chief Justice John Marshall made the ruling on that, and that was in a district court. So what they did is when he overlaid over the physical ground a state called a district, it was a fiction. And that's why it was district courts in district states. And they broke up the states into different districts. Some states being small would have one district court. Other states being large would have maybe 4 or 5 district courts located in different parts of the state. Like North Carolina has the middle district, the eastern district, and the western district. So there's 3 distinct districts, but they're in the District of North Carolina. They don't say that, but in this case, they bring it out and it says, in the District of Virginia.
All right.
So what happened was, they're not on the same footing in the District of Columbia, and the plaintiff could not sue in Virginia. So the defense brought up this, and this is a statement of the defense. Even if the Constitution of the United States authorizes a more enlarged jurisdiction than that the Judiciary Act of 1789 has given, yet the court can take no jurisdiction which is not given by that act. Therefore, call for the law which gives a jurisdiction in the case. And to quote, this is what the defense was asking the court to bring it in. Now, the response was given by the plaintiff to rebut the above statement, but the court overlooked that, and the court gave its decision and sided with the defense when Justice Marshall said, quote, the opinion to be certified to the circuit court is that that court has no jurisdiction in the case. Case dismissed. So basically, the Judiciary Act of 1789 is what gives the federal courts their jurisdiction, not the Congress, as so many people believe. And as the defense attorney said, if it's not to be found, the jurisdiction, in that act, that's a 1789, the federal court does not have it. Today, they just willy-nilly take whatever they want. But no one, that's why these old cases are so important, because it gives a lot of information as to what truly is going on. And people have been brought up not knowing this, and not knowing that the 1789 Judiciary Act, which was created, is the only act that gives any of the federal district courts their jurisdiction. So here you have direct admission that the lawyers back then were dictating the parameters in which the court had jurisdiction.
So
I cited this in the American Bar by Charles Warren, and the book, The New History, I told the fellow he might pay to reread it in light of the revelation, of this revelation the guy was talking about. So then I said, okay, now let's go back to Barron. In the constitutional book, it was printed in 1968, it states, quote, while most rights in the Bill of Rights now do apply to the states, they do so only because they are essential to due process of law. The ruling in the present case that the Bill of Rights does not apply directly to the states has never been overruled.
All right, that sounds to me like they're using the Bill of Rights like a light switch.
Yeah.
Sometimes on, sometimes off.
That's right.
Well,
now, in 1896, Barron was brought up again, and Brown versus Walker, and they broached it on self-incrimination. And now the book, I'm talking about the book, the constitutional book, because it explains in detail, it actually annotates what the court is saying. In 1956, the court reaffirmed the Brown decision in Ullman versus United States. It rejected the defendant's argument that the impact of the disabilities imposed by federal and state authorities and the public in general, such as loss of job, expulsion from labor unions, state registration and investigation statutes, passport eligibility, and general public opprobrium, is so oppressive that the statute does not give him true immunity. The statute, like the Fifth Amendment provision, protects the witness only from having to give testimony which may possibly expose him to a criminal charge. That is what the book says. They also said, since Congress needs not grant immunity from state prosecution in order to compel testimony, the question arises whether it may do so if it wishes. Right? The control over evidence